Hello guys, welcome back to the channel. I am Prakriti and today we are going to move further with what we have left in the last video, that are kinds of general defenses. There are 8 kinds of general defenses. The first is voluntary non-fit injuria, necessity, plaintiff as a wrongdoer, act of God, inevitable accidents, statutory authority and mistakes. Voluntary non-fit injuria, it is a legal maxim that means with the consent. When a person consents to the infliction of some harm upon himself, he has no remedy for that in tort. When a person given his consent for something and due to which he suffers damages, that has no remedy for that in tort. In case the plaintiff voluntarily agrees to suffer some harm, he is not allowed to complain of that, and his consent serves as a good defense against him. No man can enforce a right which he had voluntarily waived or abandoned. A person cannot enforce his right when he voluntarily have waived or abandoned that right by himself. When you invite somebody to your house, you can't sue him for trespass. It is a very common thing. When you invite someone, your consent is given that please enter into my house, then you can't sue that person for trespass. Nor can you sue the surgeon after submitting to a surgical operation because you have expressly consented to these activities. You all must have noticed that when before a surgery, a document is signed by you or either by your guardian or the person legally responsible. It clearly shows your consent, so you can't blame the surgeon for anything happened to you. Similarly, no action for defamation can be provided by a person who agrees to the publication of matter of defamatory or by himself. When you give interview to a person and that person, you have given the consent that you can publish anything about me, and then after that the person published something bad about you, can't complain about it. You can't sue that person for that defamation tort. Let's see it with an example, that is Hall versus Brooklands Auto Racing Club 1932. Many a time the consent may be implied or inferred for the conduct of the parties, as in this case. Many times the consent must be implied or inferred. Consent is not expressed everywhere and every time. It may be implied or inferred. When by your action you are giving your consent, not by expressing it. The plaintiff was a spectator at a motor race being held at Brooklands on a track owned by the defendant company. During the race, there was a collision between two cars, one of which was thrown among the spectators, thereby injuring the plaintiff. In this case, the plaintiff was a spectator and was watching a car race in the Brookland, and the defendant was the owner of that place and of the race. But when during the car race, the two cars was collision and one of the spectator was hurt by that collision, so he sued the defendant. But it was held that the plaintiff impliedly took the risk of such injury. The danger is inherent in the sport, which any spectator could foresee. The defendant was not liable. In this case, the defendant was not held liable because by impliedly or inferredly, the spectator, the plaintiff, has given the consent by buying the ticket or by any way that he has given the consent because he is watching that match in that particular area. But the risk is foreseen. It is a car race, so something must be happened. So the defendant was not held liable and he was given the defense of voluntary non-fit injuria. But one thing is very important to get this defense, that is the consent of the plaintiff must be free. For the defense to be available, it is necessary to show that the plaintiff consent to the act done by the defendant was free. It was not under coercion, misrepresentation or any other method, but it must be free. If the consent of the plaintiff was being obtained by fraud or under compulsion or under some mistake impression, such contents doesn't serve as a good defense. However, the act done by the defendant must be the same for which the consent is given. Just suppose that you have given consent for some other act, but the defendant is taking that consent as a defense for some other act performed by him. So no, it is not a good defense. For the maximum voluntary non-fit injuria to apply, 2 points have to be proved. The plaintiff knew that the risk is there. It is very important that plaintiff must know there is some risk. He, knowing the same, agreed to suffer the harm. By knowing that thing, he agreed to that. If only the first of these points is present, there is only the knowledge of the risk. It is no defense because the maxim is voluntary non-fit injuria. Merely because the plaintiff knows of the harm doesn't imply that he consents to suffer it. When you know something that is going to harm you and you didn't give your consent expressly or impliedly, that doesn't amount as a voluntary non-fit injuria. In Smith versus Baker, 1891, the act plaintiff was a workman employed by the defendant working on drill for the purpose of cutting a rock. The person had the knowledge that he has to cut a rock. With the help of a crane, stones were being conveyed from one side to another, and each time when the stones were conveyed, the crane passed over the plaintiff's head. While he was busy with his work, a stone fell from the crane and injured him. The employees were negligent in not warning him at the moment of a rearing danger, although the plaintiff had been generally aware of the risk. It was held by the House of Lords that as there was mere knowledge of the risk without the assumption of it, the maximum voluntary non-fit injuria didn't apply and the defendant was liable. In this case, it was held that merely having the knowledge of that risk doesn't mean the person is accepting it. The person is assenting it. So the maximum voluntary non-fit injuria didn't apply in this case because the person was working as a rock cutter and the crane was passing through his head with full of rocks, but he didn't know that he is going to be harmed by it, and the other persons working there didn't inform him. So the person was not liable for voluntary non-fit injuria. The next is plaintiff the wrongdoer. This is a very good general defense which the law excuses the defendant when the act done by the plaintiff was itself illegal or wrong. When a person slaps you and you hit back that person, so the person can't claim that this person hit me because he himself hit him by a slap. So it is a very good defense because the thing which was done by the plaintiff was illegal or wrong. This defense arises from the Latin maxim ex turpi causa non oritur action. When you are learning law, legal maxims are very important. You must learn it. So I am saying it again that ex turpi causa non oritur action, which means no action arises from an immoral cause. So an unlawful act of the plaintiff itself might lead to valid defense in torts. So this maxim applies not only to tort law but also to contract, restitution, property and trust. Where the maxim is successfully applied, it acts as a complete bar on recovery. It is often referred to as illegality defense, although it extends beyond illegal conduct or to immoral conduct. According to a case, Bird or Holbrook, 1828, which in this plaintiff trespassed over the defendant's land and was entitled to claim compensation for injury caused by the spring gun set by the defendant without notice in his garden. In this case, Bird versus Holbrook, 1828, the plaintiff himself was a wrongdoer and he trespassed over the land, but the defendant has put spring gun in his garden and the plaintiff was hurt by it. So he claimed for the compensation, but the court held that the plaintiff was itself a wrongdoer. He was trespassing it, so he is not eligible to claim for the compensation, and the defendant was having the defense of plaintiff as a wrongdoer. In the other defense, inevitable accident. An accident means an unexpected injury, and if the same could not have been foreseen and avoided in the spite of reasonable care on the part of the defender, it is the inevitable accident. It is therefore a good defense if the defendant can show that he neither intended to injure the plaintiff nor could he avoid the injury by taking reasonable care on the part of the defendant. It is an inevitable accident. When the accident happened, it was inevitable. It was not before seen. It cannot be assumed by the defender that it could be happened, and he cannot avoid it by taking reasonable care on his own part. So it can be a good defense that the person was neither having the intention to hurt or to cause damage to the plaintiff, neither he could foresee or even taking by reasonable care could avoid this accident. Let's see it with a case. Stanley versus Powell. It is the case